Like Charlie said, we wanted to choose subjects that were meaningful, so we've chosen the hot subject today, and I'll be presenting half of it, and then Deb will be coming up and concluding. If I can get this to work. There we are. So you saw this graph before, but it's really just to emphasise that really dry needling is great concern to the profession. At the end of last year, AHPRA did a social research, and they found, and in that social research they asked all professions within the scheme and also consumers to comment on their thoughts around the issues in their profession. And 325 Chinese medicine practitioners participated, and this is the graph of what they found. So you can see dry needling is really the issue that's concerning the profession at the moment. So I should emphasise that Chinese Medicine Board really only regulates Chinese medicine practitioners, and our talk today is talking about other professions. So we can give advice, but we don't have influence on these other professions. Might go to this one, if I can see which one to use. Now I know which way it goes. That's much better. So first of all, dry needling is not a new technique. It goes back well over 1,000 years. And the other thing to remember is it's not just growing in Australia. This is a worldwide trend. And partly it's a kudos to the industry, in fact, because basically acupuncture is getting much more popular, and at the same time the standards for acupuncture are increasing. And to some extent, dry needling reflects that some people are trying to get around these higher standards, but piggyback on the reputation of acupuncture itself. And it really falls into three areas that we'll talk about today. One is the unregistered healthcare workers who use dry needling. The other two sections are what Deb will cover, and they are the persons who come within the scheme. First of all, those registered health practitioners who have an endorsement under the scheme to use acupuncture, and this is particularly the medical profession. There's a special provision for endorsement for acupuncture. And the other one are the registered practitioners under the scheme that don't have an endorsement but do use acupuncture or dry needling. So I think the main concerns that I see anyway reflected from the profession are, first of all, is that much of the profession thinks it's unfair competition. You do 4 years training, a tertiary degree, whereas many of these practitioners have very limited training compared to yourselves. And secondly, I think there's a legitimate concern around the public safety, public health and safety, and the risk that might expose patients to. And finally is the concern around the collateral damage that it might do to acupuncture more in generally, and also to registered Chinese medicine practitioners if they don't understand, if the public doesn't understand the subtle differences. This is really just to identify the two areas. Within the states and territories, each state and territory has legislation and other requirements for healthcare workers, and these are the unregistered healthcare workers. It's interesting, when I tried to find out the number of healthcare workers, there really isn't a collation of the number of healthcare workers in this country because they're unregistered, they don't go onto a register, so it'll be a fairly onerous job to really try to find out how many there are. But a healthcare worker is basically those people who provide a health service that are not registered under the national scheme. And then you've got the national scheme, which Charlie talked about, and there's about 700,000 plus practitioners under that national scheme. And that's where the boards come in for each profession, and it's assisted with AHPRA providing the administrative support to the boards. And that is the National Registration and Accreditation Scheme, which comes under a head of legislation, which, to put it simply, is just called the national law rather than its full title. So one concern is that many people feel that it's unfair competition. And my advice would be that this is very unlikely to get a sympathetic ear from the government because, in fact, governments encourage competition to encourage more efficiency and also innovation and probably other reasons as well. And in fact, one of the principles under the Council of Australian Governments, best practice regulation, is that legislation should not restrict competition. And just give a thought to some of these. In recent times we've seen Uber come in and take over part of the territory of taxis, and the governments have been happy to sit back and watch that. Online shopping and department stores, again another very competitive area. Going right down to, I haven't got my pointer now, but I might use this one, to vaccinations by GPs, which they resisted outside groups strongly coming into that area, but now we've got vaccinations by pharmacists and it's becoming common practice. So in the same way, I don't think complaints to the government about the unfairness of dry needlers coming in is going to get a receptive ear. But where you do have the opportunity is really where you have concerns, or anyone has concerns about the safety and the potential risk or harm to patients. And the colour coding here is that the green colour coding is for those areas covered by each state and territory, and the red is the area that's covered by the national scheme. So I think as a bit of homework, you should really look at a discussion paper and a final report that came out in 2015 on a national code of conduct for healthcare workers. So they are the ones that lie outside the national scheme but come under the jurisdiction of each state and territory, and there's a code of conduct that was developed at that stage, but within that discussion paper there's a huge amount of information that should be teased apart very carefully, because it really sets the scene of how the states and territories regulate their healthcare workers. And of course under the national scheme there's legislation that covers registered practitioners, but within that there's a number of areas which cover people, not just registered health practitioners. In other words, it would cover unregistered healthcare workers as well. And these are statutory offences, which we'll cover in more detail in a little while, but these are statutory offences that apply to a person if they are breached. So the national law doesn't necessarily only just cover registered health practitioners. So first of all, I'll move into the unregistered healthcare workers using dry needling. And the unregistered is put in that way because they're not unregulated. There's a lot of regulation around healthcare workers. It's just that it's not very apparent. And this is partly because the states and territories, each state and territory regulates the healthcare workers by what's called negative licensing. They don't have a registration scheme as such that they have to go onto a register, but they can go into practice without being registered, but they have to comply with strict conditions around standards of practice, and if they don't, each state and territory has very powerful sanctions to apply against them. And so the conditions, the standards are set by that code of practice I just mentioned, and that's why it's so important. And that code of practice has now been introduced into all the states except Western Australia, which is putting them into place, and the two territories which are dragging their heels somewhat, but they will go into place because it's a decision by the Council of Australian Governments to do that. And also there's the skin penetration legislation, which as acupuncturists you're exempt from, but it does cover the healthcare workers who are doing dry needling or variations of that. And of course there's, as I said, there's powerful complainants mechanisms and strong sanctions within the state and territories. Under the national law, as I just mentioned, there are statutory offences which can apply to our healthcare workers. And this is where they might misuse acupuncturists, which is a protected title, or they give the impression that they are registered under the scheme. So these are some of the extracts from the Code of Conduct, and if you go onto the internet you'll find the Code of Conduct for each state and territory. And if you look at it carefully, it's very similar to the Code of Conduct that covers registered health workers, health practitioners. So these are just a couple of extracts from it. A healthcare worker must provide health services in a safe and ethical manner. So it's very broad but quite powerful. A healthcare worker must adopt standard precautions for the control of infection in the course of providing treatment of care. And that's where it comes down to the next part, referencing the skin penetration legislation of each state and territory. And a healthcare worker must not make claims either directly to clients or in advertising or promotional materials if they can't be substantiated. So very similar to what you are required to do in terms of if you make therapeutic claims, they should be evidence-based. So what are the available responses? So first of all, you could submit if you found a concern about a healthcare worker who's doing dry needling or claiming to do acupuncture, and that it's unsafe. You could make a complaint to the state and territories, and as I said, they have powerful sanctions to apply, including not allowing the healthcare worker to continue practice. If it's an advertising activity, and this is where the red comes in under the national law, if it's around advertising or creating the impression that they are a registered health practitioner, you could make a complaint or a notification to AHPRA, and it would be dealt with by AHPRA. And it may come back to the relevant board it would be dealt with by AHPRA in that case. And thirdly, actively promote that Chinese medicine is a regulated health profession with high standards and training. And this is particularly important. I recently saw the Facebook advertisement that had been developed by AHPRA, and that's exactly what's needed to promote the profession itself into the marketplace. And you might ask, well, what are the benefits of being regulated? And these are some of the things that should be built on. That registered practitioners must be highly trained. You have a tertiary education. Registered profession has a defined, agreed and transparent professional standards that Charlie just mentioned, which apply to all professions. The NRAS supports safe and effective healthcare. And the NRAS, that's the National Registration and Accreditation Scheme, provides status and credibility. So really, Chinese medicine is now on a par with those other 15 professions in terms of status within the regulatory status within the health professions. And that's a huge step forward. And there's a number of professions knocking on the door trying to get the same sort of status. The regulation also advances and protects the reputation of the profession. And finally, it may lead to increasing integration into the broader health system over time. And I think, as Charlie mentioned, this is a challenge for the future, but it will come, but it needs patience. But at the end of the day, really, like any advertising, the important thing is to differentiate the profession, the acupuncturist in Chinese medicine, from the other variants of acupuncture, the dry needling or the acupuncture delivered by Western medicine doctors. So I think that's a very important message, and also something that AACMA is really picking up on. So just a summary, and this is a summary under the national law. I mentioned what each state and territory is doing, but this is giving a bit more detail. So if you notice there, I've just put in the sections of the Act that apply to these statutory offences. So one is the misuse of a protected title. An acupuncturist is protected, acupuncture is not. Holding out, and that, in other words, that's giving the impression that the person is registered under the national law. Or misleading advertising, again giving the impression that the person is registered under the national law. And the question, if AHPRA is going to move forward with a prosecution in these cases, is that the use of words such as acupuncture and dry needling by itself won't carry any weight. But if you link that to the conduct of the healthcare worker, and that gives the impression that the person is registered to carry out acupuncture, that does carry weight. So it has to pass that test before it can be proceeded with by AHPRA. There's a couple of case examples. One is a recent one. AHPRA prosecuted successfully a dental technician who was doing dental work that should have been done by a dentist, and by her conduct she was giving the impression she was a registered dentist, and that person was recently prosecuted. And a cautionary one is one that dates back to 2015, which was an appeal to the Supreme Court of Victoria after a case between Penev, who was a naturopath, and the Chinese Medicine Board, where she was taken to task over the use of a variant of acupuncture. And the appeal failed because that test about giving the perception that they are registered wasn't sufficiently made. So that's a very necessary step in that process. So now we move on to the second chapter, and that's where Deb will come up and talk about the other two classes of people.
Okay, let's see, can you hear me? Have I got that at the right level? Thank you, David, and good afternoon, everybody. David has spoken to you about unregistered healthcare workers, and my task this afternoon is to briefly cover the registered health practitioners in this same space. As you know, we are operating under the Health Practitioner Regulation National Law 2009. And you are all registered under that national law with the Chinese Medicine Board of Australia. And at this point in time, I just want to table a small reminder to all of us that, as with all legislation, there's a lot of legislation that operates around Australia in the form of Acts of Parliament, statutes, which we sometimes call them, regulations, etc. They are all generated and passed by the parliaments around Australia on behalf of the citizens of Australia, which includes us. Going back to the national law. Oh, it's not working. Do I have to point it at something?
Which one are you using?
This one.
Use the other one, that one doesn't work very well.
Oh, that one doesn't work.
There you go, press that one.
It worked before.
Right, there you go. Just the one on the right.
Okay, so going back to this national law under which we're operating, there is a section, Section 97 of the national law, which enables national boards to endorse registered health practitioners, that is not Chinese medicine practitioners, you are registered. Section 97 enables the other national boards to endorse their registered health practitioners to provide acupuncture service and to use the title acupuncturist. And this endorsement does require that there be an approved qualification, approved by the national board, the relevant national board to the profession, and any of those endorsed registered practitioners must also comply with an approved registration standard. To date, only the Medical Board of Australia actually has endorsement arrangements in place, and it does have an approved registration standard, and currently there are only 592 registered medical practitioners who actually have an endorsement for acupuncture. That's about 0.52% of the medical workforce. And I'm sure you're very well aware that this endorsement of medical practitioners in particular to practice acupuncture is linked to certain Medicare items. And here again raises the issue of legislation. The Medicare Benefits Scheme operates under a specific piece of legislation, that's the Health Insurance Act 1973. And when legislation is generated and passed by parliaments, one of the common aspects of legislation is that there are many statutory authorities around Australia whose sole job under the legislation is to implement and enforce the specific legislation they're created under. In the case of the Health Insurance Act 1973, that is implemented by the Federal Department of Human Services. So yes, there are 5 Medicare items based upon which medical practitioners can be remunerated for providing acupuncture services. 4 of them require that practitioner to be endorsed. There are only 592 of those, and those 4 items attract the highest remuneration level. The 5th one, yes, which we know is accessible to any medical practitioner, even if they're not endorsed, attracts a rebate of $25.95. I think Charlie already mentioned that there are also when we get concerned about the lack of qualification of non-Chinese medicine practitioners practicing acupuncture, I think it's fair and reasonable to remember that some of them actually are quite well qualified. There are, 384 Chinese medicine practitioners who are also registered with another national board. So our emphasis today, as David has already explained, is that we're going to just set out to you what your available responses are. And in relation to this endorsement provision, it's there in the national law. The medical board has implemented it. One of your first response really is to provide comment on the registration standard for endorsement. If any of the other boards were to develop such a registration standard, and when the Medical Board of Australia reviews that registration standard, as with all standards for all of the 15 national boards, they must be subject to wide-ranging public consultation. They must ultimately be approved by the Ministerial Council. They are not ever approved just by a national board, and they must be published on the relevant board's website. The current Medical Board acupuncture endorsement standard was actually published in December 2012, so it could be that it may be reviewed in the near future. Okay, moving on to another group of registered practitioners, which I know that you're aware of, who are not endorsed to practice acupuncture, but as we know, they are using acupuncture, and sometimes they refer to it as dry needling. As you also know, and as David has explained, the national law is based on title protection. That is the primary mechanism that the national law uses to protect the public. So the decision that was made by the Parliaments of Australia when they generated and passed that legislation. The protected title of interest to you today is acupuncturist. The national law does not, with a couple of notable exceptions which I shan't go into, generally does not protect practice, and it does not protect the practice of acupuncture, as it also does not protect the practice of physiotherapy or psychology, etc. So, even though we know that some of these other practitioners are advertising and practicing acupuncture without referring to themselves as acupuncturists, there are some requirements that they must be very careful not to give a misleading impression, and I'll come back to this. There are actually varied subsections of the national law which go to the issue of title protection. It's quite a complex area of law, and I just want to draw your attention specifically to section 117 and 1119. Don't like to bore you with the numbers, but it is important. These two specific sections specifically restrict registered practitioners from claiming to be registered in another profession, claiming to be registered in a division of a profession, or falsely claiming to be endorsed in any way. The important thing is that in this specific section, well, these two sections, 117 and 119, those two sections expressly state that for a registered practitioner, a breach of those sections is not an offence. And when we refer to title restrictions and the restrictions on advertising, what we're talking about is offence provisions. The offence provisions under the national law generally refer to persons, which includes corporate entities. And an offence under the national law is dealt with by AHPRA. It is not dealt with by any of the national boards. In relation to these two sections, the subsections expressly state that an offence against these sections is not an offence. What happens in these in these two subsections is that any breach of those provisions is dealt with by the relevant national board. So registered health practitioners are held accountable through their national board. I've been given the wind up and I've hardly had any time. So going back again to the available responses to you. When it comes to these registered practitioners, if you have concerns about unsafe practices, that is a concern that may go to the issue of unprofessional conduct or unsatisfactory performance. And the avenue open to you is to lodge a notification, the avenue that is open to everybody in Australia. And that will be dealt with by the relevant board. If you are concerned about alleged breaches of the offence provisions or misleading advertising, the available response is to lodge an offence complaint, and that will be dealt with by AHPRA. So your concerns about these groups of practitioners basically fall into two different areas. There's the offence breaches, and as David's already explained to you, we have consulted with the AHPRA lawyers. Just the use of the word acupuncture or similar words on its own would not amount to a title breach. It needs to be accompanied by additional conduct on the part of that registered practitioner, which when viewed in the circumstances, in the context of what they're doing, would lead a person to believe that they are a registered acupuncturist. And this would need to be tested at the magistrate's court. And the strongest test case would be if a patient actually complained that they were misled. The second area is, as I've already explained, if there's evidence of unsafe practices, you need to lodge a notification, and that will be dealt with by the national board. The medical board, the physiotherapist board, the osteopathy board, whichever board has registered that particular practitioner. As David also said earlier, the CMBA only has authority to regulate Chinese medicine practitioners. So today we've only been talking about the other professions which your board does not regulate. So basically, we're here today just to provide you with information. Both AHPRA and the CMBA are very aware of the concerns that you have expressed on many occasions about non-Chinese medicine practitioners. Fundamentally, we have a piece of legislation that's based on title protection as its primary protective mechanism, and we have AHPRA and the board who have limited powers. AHPRA deals with statutory offences. All the national boards deal with their own registered practitioners, and there are state and territory health complaints entities who deal with the unregistered health workforce. There are a lot of statutory authorities around the country whose job it is to implement and enforce those laws. And you know, as citizens of Australia, we don't want statutory authorities running around reaching beyond their powers, reaching beyond the legislation that they are entrusted to implement. So in closing, I just want to say I hope that David and I have done our best to succinctly and clearly explain to you what the situation is and what your options are to take up your concerns with an appropriate authority. Thank you.